So this video is about novation agreements, what they are, considerations as you're putting together a novation agreement, the risks involved in novation agreements, and recommendations for structuring these. Sometimes investors are having a difficult time dealing with sellers that may not want to do a subject to or wraparound type transaction. They either want a sale or something different. And so we need to find a way to help investors navigate novations so they understand the different risks that are involved in these transactions. So let's just walk through those for a moment. So as we're considering doing a novation, we need to consider who our seller is and what is their situation. Are they a sophisticated seller or not? Are they current in payments or are there arrears? And what's the size of those arrears? What's the condition of the property? Great condition? Does it need minimal repairs or a lot of repairs? And as we're going through this, remember, our seller has no idea what a novation agreement is or how it works. And so you've got to be able to explain things to them properly and correctly. So as we're going through these considerations, we need to look at what the risks are in a novation agreement. You know, besides the status of the mortgage and the status of repairs, the question becomes, does our seller have any liens against them? Have you done a check on the title of the property before you go to a contract or something with the seller? Are they in financial straits where liens could get recorded against them? Could an IRS lien be recorded? Certainly. Could a judgment lien be recorded while you're navigating this? Certainly. All of these things are options that could happen when you're navigating a novation agreement. Then I hear in the marketplace that investors are filing a document they call a notice of intent. And I've seen this precursory notice before. And I look at it and I go, what in the world is this? What does it really say? Who signed the notice of intent? Did the investor sign it or did the seller sign it? Is it recorded of record or not? You can't just execute a notice of interest that really says nothing because you might know what the intent is, but the seller doesn't understand it. And one thing I can guarantee you that when you go to a title company and all there is this notice of intent that is not signed and notarized by the seller, may not be recorded of record, I don't know. A title company, for the most part, isn't going to know what it is either. And so you've got to navigate those differently and more appropriately. You know, is it a mortgage statement? Is it an agreement to pay you X dollars? And how did you get to those dollars? This is not a lien on a property. And so you've got to think through all of these issues when you're considering doing a novation. I also hear that there is a situation where you are acting as a marketing rep, sort of like a realtor, but the investor really isn't the realtor. Well, the issue with that becomes, are you violating some rules of your real estate commission? Are you acting as a realtor? I don't know. These are problematic and you need to consider the risk factors involved in those items. Then what happens if after the sale of the property, there's a lawsuit for failure to disclose or some other issues? Who's responsible for that at that time? Is it the investor who handled the sale and acted as the marketing rep? Is it the seller? Is it both of you? I don't know. But so often what I see with novation agreements and transactions like this is a lot of people want to find ways to shortcut items, but they don't realize all the considerations and risks that can legitimately pop up. And what you have to be aware of, guys, is that these things do happen in real life. So as we go through these transactions, there are just things that we need to understand. What is our goal to accomplish? I suggest you always do these within a corporate entity. We need to know who our seller is, what's their situation, and what's going on. Don't overcomplicate matters because the seller won't understand what you're telling them. Sometimes they will, but most often they probably won't. So let's go through what I think are the best ways to do a novation agreement from top to bottom with increasing risk along the way. So my first suggestion is buy the property from the seller using a subject to transaction or a wraparound transaction. If you want to limit the time frame, do a wraparound transaction with a short time frame. Control the deal. Get the seller out of the situation and eliminate the negative issues that could arise. Now, if your seller is unwilling to do that, then let's go to our second option. The second option is create a corporate entity of some type, a corporation, an LLC, whatever it might be, that you and your seller may own together in some format. Transfer the property into the LLC, let's say. If you're bringing the loan current, if you're making repairs, now have the LLC borrow money from you or your private lender, whatever it might be, for those purposes, and put a second lien on the property so that now that money is protected. Then have an agreement, you can do this through corporate minutes of some type, that says how the transaction is going to be handled. Who's responsible for making repairs to the property? Who's going to make the payments? Who's going to list the property for sale? Who will be used? Will it be a realtor? If you have one in mind, great, identify it. How will the marketing be handled? Reductions in payments. Do some forward thinking along the way with this and try to eliminate all the negative issues or items that may pop up along the way and get them out of the way up front. It clears the path for you to control the property, bring the loan current, make the repairs, and go to market and sell the property. So the next scenario, which is really not a good one, is to go to contract with the seller to buy the property. And I see a lot of investors trying to navigate a novation agreement under a contract for sale. And oftentimes they will mix in a contract for sale with an agreement to repair and things of this nature. And I really think you're mixing apples and oranges along the way. And then you have to think about what if you're unable to assign that contract to a third party? What if you're unable to sell the property? Because guys, what if really does happen? And then have you obligated yourself at that point in time to buy the property because you executed a contract for sale? Or did you put a sufficient out clause or maybe a longer term option period in that contract? 30-day, 60-day, 90-day agreement. Along the way, did you have the right, since you're not the owner of the property, to sell the property? You might have the right to assign it, but do you have the right to go to a third party to actually sell that home? Because you'd have to close transaction one, the AB side, in order to effectuate the BC side of the transaction. You know, with that, I can just imagine investors who spent tens of thousands of dollars bringing a loan current, stopping the pre-foreclosure that was ongoing maybe, making repairs, and all of a sudden, all of this blows up. And I will tell you, I've had to deal with investors who have been put in that exact same position. We don't want to be there. So if that doesn't happen, did you have the option under your contract to maybe buy the house subject to the existing debt? Now you've got to make certain you've had some proper disclosures along the way between you and the seller at that point in time, or get those executed. From there, how would your funds be protected? If you were able to buy the property, obviously your funds would be protected. But what if they weren't? A lot of investors fall back on this notice of interest that's being floated around in the marketplace. But what is that notice of interest? And we talked about that earlier because I really don't know what it is. It's not a lien on the property. It's not a mechanic's lien because the seller has to hire someone to do the work and then not pay them. And so you have to understand all the variations of a novation, liens, things of that nature, and how you protect yourself. So if you're going to run this under a contract, if you're going to utilize this notice of intent, you need to make certain, first off, that the seller signs it and it's notarized for recordation purposes. You want to spell out properly in this novation or in this notice of intent, how are you getting paid? How are you getting reimbursed? And We want to create this document so that it creates a quasi-lien on the property and an agreement where the seller is directing a closing agent to pay the investor based upon some type of a certain formula that they can follow easily and come up with a payment amount. Otherwise, you're going to rely upon obtaining that seller's payoff for you in some format, which may be problematic if that seller's not cooperating at this point in time. And also, guys, keep in mind, a seller can terminate your power of attorney at any time. Just because it's been executed doesn't mean they can't terminate it. And again, take a moment and imagine that you have put money up to bring a loan current. You have put thousands of dollars of repairs in the property and hours in marketing this home, and all of a sudden your seller terminates the power of attorney. Maybe he terminates your contract for non-performance. Maybe he sells it to a third party outside of a title company or something, and it's already closed. What happens? The bottom line is this buys a lawsuit, and the one thing we investors don't want to get involved with is a lawsuit. So along the way, if you're going to use the novation agreement to market the property for sale, using a contract for sale in some format and acting as a marketing agreement, I would just suggest and recommend that maybe you use transactional funding to close the AB side of the transaction, actually close the deal and sell it to the back-end home buyer appropriately. Avoid any issues that you could run into with your local real estate commission scenario where you're not acting as a realtor and being unlicensed in that regard. And finally, we all want to accomplish the same goal of getting the transaction closed and making money. The main goal is learning how to be smart and thinking through your deal from start to finish and understanding all the various issues and risk factors that can pop up at any time. The best way, of course, as I said earlier, control the transaction, get the seller out of the picture completely. If not, go to your second best mechanism. Put it into a corporate entity, control the deal, protect the money you put in the deal with a legitimate lien on the property, so you eliminate the negativity of a seller going around you and selling it to a third party. And guys, I'm just going to say again, already seen that happen several times, and the investor is out of luck in those scenarios. His best option then is to file a lawsuit against a deadbeat seller who has no money most likely. So be smart, understand novations and what you're doing, think through your transaction appropriately, and do what is best for you. And I understand we run into problematic sellers all the time who won't do the creative finance, who don't want to put it into an LLC. I got it. Just find a way to make sure you get things recorded of record and protect you and protect your money. So if you like this video, guys, give us a thumbs up. If you got any comments, give us a comment below or other videos you'd like us to do for you. We'd love to answer your questions along the way. So if you want to learn more creative strategies like this, check us out over at theownerfinancenetwork.com. You'll find some programs that are available that'll help you out along the way. We'll see you all next time.